Greetings from Bharat Institute of Law. Myself, Archana.K, Assistant Professor, Bharat Institute of Law, Bharat Institute of Higher Education and Research. In this session, we will be covering the topic Forest Laws in India. This topic is covered under Environmental Law. In this session, we will be dealing with four major pieces of legislation that provides for protection, preservation and conservation of forests in India. Before looking into the piece of legislations, their overview, we will be looking into the brief history of protection of forest in India and also understanding the very meaning of the term forest. In this session, we will also be covering two case laws related to protection of forests. Now, let's move into the session. Forests are one of the many natural resources that we are blessed with. Forest contributes to increase the fertility of soil, prevents soil erosion, and promotes perennial stream flow in rain-fed rivers. Forests play a very important role in providing shelter to wild animals, preserving gene pools, and protecting the tribal population. Besides the environmental and ecological benefits, forest also provides economic benefits as well as brings revenue to the state, supplies raw material to industries, and act as a source of fuel and fodder. From a very young age itself, we would have studied and understood various uses and advantages of forests and also the need to protect them. One way in which forests are protected is through implementation of various laws. The laws that are in place with the objective of conserving and preserving forest has a common objective of bringing balance between the ecological benefits and economic benefits. It means that the laws in place definitely takes into consideration the economic benefits that we reap from the forest and does not make any absolute restriction in the use of forest. The laws in general provides only for some reasonable restrictions on the use of forest with the objective of conserving and preserving the forest. There are four major enactments that deals with protection of forest in India. They are the Indian Forest Act of 1927, the Forest Conservation Act of 1980, the Biological Diversity Act of 2002, and the Forest Rights Act of 2006. We will be dealing in detail about these acts in this session. Before we discuss about the piece of legislation relating to forest in India, let's look into a brief history of how the protection of forest was realized and how the laws relating to protection of forest evolved. Treating nature and treating trees as gods were considered as one of the means by which forests were protected. Cutting of certain trees were considered even as sin. Though we can say that these are mere superstitious beliefs, it was once a means by which forests and trees were protected. Looking into the history apart from the mythology, Emperor Ashoka is known for his work to protect forests and for planting trees along public roads. So afforestation was considered as another means by which forests were protected and preserved. During the British period, it was observed that there were cutting down of many trees because the English Royal Navy believed that the safety of the empire depended on its wooden walls. To make the wooden walls to protect the country or an empire, various trees were cut. After this realization, in the year 1800, a committee to enquire the availability of teak in South India was set up by the British government itself. In 1805, a committee to assess the capacity of the forest was also set up. The very first forest law in India was enacted in the year 1865, and the enactment of this act also paved way for establishment of a forest department. One of the main lacuna of this particular act and this particular establishment was that it lacked any deterrent punishment for doing any act that is against protection and preservation of forest, and gave only meager powers to the forest officers in regard to protection of forest. The same law was revised in the year 1878, which claimed absolute control and ownership rights of the state on forest. The revised law of 1878 also recognized the rights of nomads of the forest and of other nearby dwellers in various areas. The outline of these laws are still of significance because the current laws that are in place, which are meant for protection and preservation of forest, has reference to this. Now, let us look into the four major pieces of legislations relating to the protection of forest. So these four laws are currently in place. To start with, Indian Forest Act of 1927. This act is divided into 86 sections under 13 different chapters. The act provided for preservation of forests and promotion of forest produce and collection of revenues. It also prescribed the manner and limits within which forest resources could be exposed to industrial and commercial purposes. The Act basically consolidated the laws relating to forest, and it was enacted to regulate the transit of forest produce. It also provided for levy duty on timber and other forest produce. Though it was considered as one of the major enactment that provided for protection of forest, it failed to define what forest is. every time we take into consideration the definition or meaning of forest in India, we consider the definition provided by the Food and Agriculture Organization. According to the organization, forest means all lands bearing vegetative association demarcated by trees of any size, exploited or not, capable of producing wood or other food products. Though the Indian Forest Act 1927 does not define forest, it provides for definition of other terms like forest produce, forest offense, timber, trees, etc. One of the important feature of the Indian Forest Act 1927 is the classification of forests. The Act classifies forest into four different categories. That is, the reserve forest, protected forest, private forest, and village forest. This classification is based on the type of activities that are permitted in these forests. The state government may constitute a reserved forest just by issuing a notification in the official gazette. The state government may declare any forest land or wasteland which is the property of government, or any land over which the government has proprietary right as reserved forest. The notification issued by the state government will specify the situation and limits of the reserved forest area. An officer called the Forest Settlement Officer would also be appointed to the notification, who will inquire into and determine the existence, nature and extent of any rights alleged to exist in favor of any person in or over any land comprised within such limits, or in over any forest produce, and to deal with the same as provided under this particular act. Section 26 of this act enlists the activities that are prohibited in the reserved forest area, which includes clearing of forest for cultivation, setting fire, kindling, keeping or carrying any fire equipments, trespassing or pasturing cattle or permitting cattle to trespass, quarrying stone, clearing or breaking up of any land for cultivation, hunting, killing or catching of elephants, etc. The state government also has the power to declare any particular area as protected forest areas. The only difference between uh, notifying any particular area as reserved forest area or as protected forest area is in the nature of activities that can be carried out in this particular areas. We already dealt with the acts that are prohibited in a reserved forest area. Likewise, Section 33 provides for the acts that are prohibited in a protected forest area, which is almost similar to that of reserved forest area. It is to be noted that if at all there is any non-compliance on the part of anybody, or if anybody does any act in the reserved forest areas or protected forest areas that are specifically prohibited, they will be punished with imprisonment that may extend to 6 months, and fine that may extend to rupees 500. This being an old act, rupees 500 is considered as a huge amount, but it is a sad fact that this act has not been amended since then. The state government may also assign to any village community the rights over a land which may be a part of a reserved forest for the use of the community. Usually, forested community lands are constituted into village grazing reserve. The state government is also having the power to declare any part as a private forest area, if at all it is not owned by the state government. So when a state government declares any forest area as a private forest area, then the owners of that particular area is having the responsibility to ensure that certain acts are not carried out in that particular areas. So this is basically an overview of Indian Forest Act. Next, we are going to discuss about the Forest Conservation Act of 1980. This act was enacted in response to the rapid decline in the forest covers in India. This was the first law enacted after independence for the purpose of conservation of forest. The objective of this act was also to fulfill the constitutional obligation provided under Article 48A of Indian Constitution. This particular act provides for regulation of the diversion of forest lands into non-forestry purposes. The Act allows the diversion of forest land only for certain purpose, such to meet the developmental needs for drinking water projects, irrigation projects, transmission line, railway lines, roads, power projects, defense related projects, mining, etc. But it is also important to note that for such any conversion of forest lands for non-forestry purposes, a compensatory afforestation is also stipulated, and a catchment area treatment plan, wildlife habitat improvement plan, rehabilitation plan, etc. are to be implemented under the provisions of this Act to mitigate the ill effects of diversion of such vast area of green forest. The Forest Conservation Act of 1980 also provides for a provision to monitor the effective implementation of this Act through the establishment of Compensatory Afforestation Management and Planning Authority. This particular authority has been constituted under this Act and functions at a national level. According to Section 2 of this Act, prior approval of the central government has to be obtained by the state government or other authority for undertaking any of the activities that was mentioned previously. A proposal has to be sent to the central government in the form specified in the Forest Conservation Rules of 1982. In case the proposal for clearances get rejected, a person aggrieved by an order granting environmental clearance can appeal to the National Environmental Appellate Authority set up under the National Environmental Appellate Authority 1997 within 13 days from the rejection of this proposal. Though the original provisions of this Act state so, now the appeal can be made before the National Green Tribunal. With the establishment of National Green Tribunal in the year 2010, the National Environmental Appellate Authority set up under the 1997 Act ceased to exist. The next act that we are going to deal with is the Biological Diversity Act of 2002. This act was brought into force in consonance with the Convention of Biological Diversity 1995. This act has been brought into force to ensure the conservation of biological diversity, sustainable use of its components, and fair usage of its resources in order to prevent the overuse or eventual destruction of biodiversity. This particular act provides for regulation of access to biological resources of the country. It also ensures conservation and sustainability of biological diversity. It also provides for protecting the knowledge of local communities regarding biodiversity. This particular act secures sharing of benefits with local people as conservers of biological resources and holders of knowledge and information relating to the use of biological resources. It also provides for protection and rehabilitation of threatened species. It also ensures involvement of institutions of state governments in the broad scheme of the implementation of Biological Diversity Act through the establishment of dedicated committees as well. How does the Biological Diversity Act regulates the access to biological resources? This particular act mandates that anybody who is making use of any biological resources to manufacture something or to produce something and get a patent for that, then such act has to be informed to the National Biological Diversity Authority or the state biological diversity boards that has been established under this act. So only after the consent obtained from these particular boards and authorities, any person can make use of the biological resources of our country. The National Biodiversity Authority has been set up under the Ministry of Environment and Forest by the Government of India in the year 2003. The state biodiversity boards were also created in the 29 states along with the biological management committees for each local body. So, the National Biodiversity Authority functions at the national level and the State Biodiversity Board functions at the state level and the biological management committees functions at the local level. This particular act also provides for declaration of biological heritage sites which are the sites that are rich in biological resources. It also regulates research activities using biological resources by mandating the consent of the National Biodiversity Authority or State Biodiversity Board. The outcome of a research that had utilized the biological resource from India cannot be given to a foreigner or a foreign company without the consent of the National Biodiversity Authority. It also mandates that any benefit that is reaped from the use of biological resources of India has to be shared with the indigenous people. So, rather than protecting the forest or the biodiversity of our country, this particular act also protects the rights of indigenous people and also protects traditional knowledge. The next act that we are going to deal with is the Forest Rights Act of 2006. The original title of this particular act is the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act 2006. It was enacted by aiming at giving ownership rights over forest land to the traditional forest dwellers. This act concerns the right of forest dwelling communities to land and other resources. The Ministry of Tribal Affairs was established as an independent ministry in 1999 to deal specifically with scheduled tribes and their rights. This ministry can be called as the torchbearers of this particular act. The criteria for designating a tribe as scheduled include having primitive traits, dwelling in geographical isolation, having a distinct culture, less or no contact with the outside world, and being economically backward. This particular act thus mainly protects the rights of such scheduled tribes. This act identifies four different types of rights. One is title rights, the second is use rights, the third is relief and development rights, and the fourth is forest management right. The act also vests on the forest dwellers with duties. The duties to conserve and preserve forest. Under this Act, the Gram Sabha shall be the authority to initiate the process for determining the nature and extent of individual or community forest rights or both that may be given to the forest dwelling scheduled tribes and other traditional forest dwellers. So that is all about the four major acts that provides for protection of forest in India. So what we have to construe here is these acts not only provide for protection of forest but also provide for the protection of the interest or rights of the forest dwellers because it is these people who can contribute more in conserving the forests. Now, let us discuss two case laws relating to forest protection. The first case is State of Tripura versus Sudhir Kumar Ranjan. In this case, the question was about the legality of rules made by the state government in relation to transit of forest produce, charges to be levied on the forest activities, etc. The High Court observed that the rules violates the constitutional provisions relating to freedom of trade. Whereas the Supreme Court observed that the rules falls within the ambit of reasonable restrictions and hence are valid. It was finally held under this case that regulating the forest activities is necessary to protect and preserve forests. So this is a case where fundamental rights were put below the protection of forests. Restriction on any act with an aim to preserve, conserve or protect forest can be considered as a reasonable restriction. The next case is the Center for Environmental Law versus Union of India and others. This case pertains to the issue of settlement of rights in national parks and sanctuaries. This ordered for checking unauthorized settlements, poaching and dereservation and denotification of forest. No forest, national park or sanctuary can be dereserved without the approval of Supreme Court. So this was the observation made in this case. This particular case paved way for establishment of a monitoring committee and compensatory for afforestation management and planning agency. That's all with this session. See you in some another session. Thank you.